Yes,
President. My name is Dan Salamad. I'll be holding the for Mr. Mbithe and Mr. Shadra. The matter is coming up for hearing from our party.
we are done with the, sorry, Kofuna. Yes.
No, sorry. I wanted to go on record. There was an advocate we were together called Angela.
Yes. Yes.
She's not present in court today because she was arrested, arraigned before locals today. Where the state is sitting for 21 days. The ruling is coming up tomorrow at 2 p.m. That's the daughter of the first respondent and the sister to the second respondent. She can be put on record. I'll be holding her brief. Thank you.
Okay, so this is the ruling. The application for determination is the one dated 31st of July 2026 and is premised and brought under Article 49(1) F and G of the Constitution, Section 36A of the Criminal Procedure Code. The same is supported by the affidavit of number 85256, Corporal Romana Odur, an officer attached to the DCI Homicide Investigations Bureau. In the application, the prosecution craves that the court grants an order placing the first and second respondents in custody at Kilimani and Kileleshwa police stations respectively for a period of 30 days to allow the applicant's investigators complete investigations in a case of murder in which the respondents are suspects. The prosecution was led by Ms. Naomi Wanjiru and Mr. Nyaga. Mr. Kofuna was watching brief for the deceased family, and Mr. Katunga Mbuvi, Mr. Danson Umari, Mr. Shadrack Omboi, and Mr. Cliff Mbithe appeared for the respondents. The prosecution submitted that they were investigating a case of murder of one Dr. Victoria Nzunya Mutiso, PhD, formerly director of African Institute of Mental and Brain Health, who was murdered on the 29th of July 2026 within Upper Hill in Kilimani sub-county in Nairobi County after being trailed and fatally shot by unknown gunmen while she was riding on an Uber registration number KDJ 609D. In addition, and after a report was made at Kilimani Police Station, via OB number 35/29/07/2026, the applicant took over the investigations from DCI Kilimani, and on 29th of July 2026, took over investigations from DCI Kilimani on 29th of July 2026 and initiated fresh investigations. In their preliminary findings, the prosecution submitted that investigations have pointed out that there was a land dispute culminating to a civil suit, which was filed by the first respondent at Machakos Law Courts, case number MCELC/A111 of 2025, against the deceased family property, reference number LR number 1504/13, where the deceased was the third defendant regarding ownership of a piece of land, LR number 1504/13, situated within Mlolongo Weighbridge in Athi River Sub-County, a matter which is being investigated by DCI Mlolongo via inquiry number 14 of 2026. And that the said land dispute brought about an eviction and demolition of the deceased family's properties on the piece of land LR number 1504/13, which was filed by the first respondent, and shortly after the eviction and the demolition of the deceased family properties, she started to receive threats to her life, whereby she will be constantly betrayed by unknown men riding on motorbikes while she was driving. And on 7th of July 2026, she was driving along Gong Road near Junction Mall when unknown men on a motorbike pointed a gun at her and tried to shoot her. However, she was able to flee the scene and later filed a threatening report at Kilimani Police Station via OB number 63/07/07/2026. And that after this incident, the deceased reported to the police and her husband that the pillion passenger who was among those who trailed her, she identified him as the second respondent. On 27th of July 2026, while driving from her homestead to her office, she was again trailed by unknown men on a motorbike. She again reported to the police and the investigations were underway. In addition to that, was that the first respondent is an ex-wife of the deceased husband, whereby the first respondent divorced with her ex-husband in the year 2001, and that during the arrest of the second respondent, he was found to have crucial exhibits relating and belonging to the deceased person, which the investigating team strongly believes that the said materials were shared by the second respondents with the unknown gunman before she was brutally murdered, and the same was pending for forensic analysis. The prosecution argued that the investigators have established that the respondents are well known to key prosecution witnesses, who include members of the deceased family and other persons connected to the long-standing land dispute, and that forms part of the investigations, and that the respondents are aware of the identity of these witnesses and the nature of the evidence they are likely to give, and if released at this stage, there exists a real and substantial likelihood that they may interfere with, intimidate, influence, or otherwise compromise the witnesses, thereby prejudicing ongoing investigations and the administration of justice. This apprehension is further strengthened by the fact that the deceased had previously reported threats to her life prior to her murder, and that one of the principal witnesses is the husband of the deceased, who is a crucial identifying witness, and owing to the traumatic circumstances surrounding the brutal murder of his wife, he is yet to record a comprehensive statement with investigators, and that his evidence is central to the investigations, particularly regarding the previous threats made against the deceased and the identification of the person suspected to have trailed her before the murder, and that his vulnerable emotional state necessitates protection from any actual or perceived intimidation, and the release of the respondents before his statement is fully recorded may compromise the quality and completeness of his evidence. The prosecution further argued that critical forensic examinations remain incomplete, including ballistic analysis of the recovered exhibits, forensic examination of CCTV footages, analysis of call data records, forensic examination of the motor vehicle used during the commission of the offense, forensic examination of the exhibits recovered from the second respondent, and that these investigations are indispensable in establishing the identity and respective roles of all persons involved in the offense, and require additional time to be concluded before appropriate charges can be preferred, and that the release of the respondent at this stage poses a significant risk of collusion with other suspects who remain at large, enabling them to coordinate their accounts, destroy documentary or electronic evidence, frustrating investigative efforts, and ultimately undermine the administration of justice. And continued detention is therefore necessary not only to facilitate investigations but also safeguard their own security pending the conclusion of investigations. Furthermore, the prosecution argued that the matter had generated widespread public interest and significant public outrage due to the circumstances under which it was committed and the profile of the deceased, and the identities of the respondents have become known to members of the public and to the deceased family. Consequently, there exists a genuine apprehension that if released before investigations are concluded, the respondents may be exposed to retaliation, mob justice, or other threats to their personal safety, and their continued detention is therefore necessary to not only to facilitate investigations but also to safeguard their own security pending the conclusion of the investigations. The prosecution placed reliance on a plethora of authorities in support of its submissions on the applicable principles governing the grant or denial of bail. They relied on the Republic, in the case of Republic versus William Imoli Shigali, alias Imo, and two others, criminal case number E006 of 2025, the court considered the circumstances capable of constituting compelling reasons for purposes of denial of bail. The prosecution further relied on the Republic versus Ndenge Mackenzie and 17 others, criminal miscellaneous application number E007 of 2023, in which the court considered inter alia the question of public outcry and its relevance in the determination of whether compelling reasons exists to warrant the denial of bail. On the gravity and seriousness of the offense, reliance was placed on the case of Republic versus Pascal Ochieng Lawrence, 2014. The prosecution also cited the Malawian decision in John Zenus Ungapake Tembo and two others versus the Director of Public Prosecution in the Malawi Supreme Court, Criminal Appeal number 16 of 1995, for the proposition that the gravity of an offense may in appropriate circumstances constitute a factor indicative of the likelihood of an accused person absconding and consequently becoming a flight risk. On the issue of interference with witnesses, the prosecution relied on the case of Republic versus Dwight Sagaray and four others, and the case of Republic versus Jaktan Mayende, for the proposition that the risk of interference with witnesses is a relevant consideration in the determination of an application for bail, and that such interference is not necessarily confined to the period after the commencement of the trial, but may occur at any stage of the criminal justice process, including investigations. The prosecution further invoked the South African decision in the case of South Africa versus Dlamini and others, the Constitutional Court number 21 of 1998, in which the Constitutional Court of South Africa considered, among others matters, the nature of the offense capable of generating public outrage and relevance of such considerations in the context of bail. Counsel for the victim's family associated himself fully with the prosecution submissions and urged the court not to grant bail. Counsel for the respondent, Mr. Cliff Mbithe, eloquently and vehemently opposed the application seeking orders for the respondents to be detained in custody for a period of 30 days. Counsel submitted that although Article 49 of the Constitution does not expressly define what constitutes, and I quote, compelling reasons for purposes of limiting the right to bail, such reasons must by their nature be weighty, cogent, and sufficiently compelling as to justify the deprivation of an accused person's constitutional right to liberty. Counsel further submitted that the respondents were arrested on 29th of July 2026 and were not presented before the court within the constitutional prescribed period of 24 hours. It was consequently contended that their continued detention was in violation of the safeguards guaranteed under Article 49(1)(f) of the Constitution, which requires an arrested person to be brought before a court as soon as reasonably possible, but not later than 24 hours after being arrested, or by the end of the next court day, where the 24-hour period falls outside the ordinary court hours. Counsel further submitted that there was no necessity for the respondents to remain in custody to enable the investigative officers to undertake the outstanding investigative processes. In particular, he contended that the retrieval and analysis of call data records, examination and analysis of CCTV footage, forensic examination of the motor vehicle, and the conduct and completion of the postmortem could all be undertaken without the respondents being detained in custody. Counsel also addressed the issue concerning the mental state of the other witness, submitting that the same did not constitute a sufficient basis for the continued detention of the respondents. He maintained that the outstanding investigations could be carried out independently of the respondents' continued incarceration, and that their detention for a further period of 30 days was therefore neither necessary nor justified. He submitted that there was no evidence demonstrating that the respondents were at risk of harm from members of this public. On the contrary, he contended that the real threat to the respondents emanated from police officers who allegedly assaulted and subjected the second respondent and his sister to rough treatment. Counsel submitted that the alleged threat from the public was therefore unsubstantiated. On the alleged risk of interference with the witnesses, counsel submitted that the court had not been furnished with the relevant witness statements or any other material demonstrating the existence of such a risk. He posed the question as to how the respondents could interfere with witnesses whom they did not know. He further distinguished the present case from the case of Republic versus Jackton Mayende, where there was evidence of actual interference with witnesses, whereas in the present matter, no such interference had been demonstrated. Counsel further relied on the case of Republic versus Dwight Sagare and 4 others, where he submitted that Justice Rosemary Korir held that in alleging interference with witnesses, material before the court to substantiate the apprehended interference. Similarly, reliance was placed on the case of Republic versus David Richard Alden, criminal case number 48 of 2012, where Lady Justice Lecit emphasized the need for the alleged likelihood of interference with witnesses to be established by evidence, lest the allegation be left at large without evidentiary foundation. On the alleged likelihood of absconding, counsel submitted that the prosecution was equally required to place before the court material evidence demonstrating that the respondents were a flight risk, and he relied on the case of Oyamo versus Republic in support of his submissions. He urged the court to take into account the personal circumstances of the respondents. He submitted that the first respondent is a 75-year-old senior citizen, while the second respondent is an advocate of the High Court of Kenya. He contended that these circumstances militated against the suggestion that the respondents were likely to abscond or otherwise evade the due process of the law. With regard to the dispute concerning the land, counsel submitted the eviction in question had been lawfully undertaken and that the circumstances surrounding the disputes did not provide a basis for the continued detention of the respondents. He further invoked the constitutional protection of fundamental rights and freedoms. He submitted that Article 19 of the Constitution makes it clear that the rights and fundamental freedom in the Bill of Rights belong to each individual and are not granted by the state. He further referred the court to Articles 20 and 21, which provide inter alia that the Bill of Rights applies to all laws and binds all state organs and all persons, and that it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. Consequently, he urged the court to invoke its constitutional mandate to uphold and enforce the respondents' rights and fundamental freedoms and to decline the prosecution's request for their continued detention for 30 days. In addition, Counsel Katunga Mbithe submitted that there was violation of the suspect's rights as they were brought to court 36 hours later, and their continued detention would perpetuate an illegality. He further submitted that paragraphs 21 and 22 of the supporting affidavit clearly deponed that the perpetrators were unknown and the respondents had been exonerated. He relied on Article 52A of the Constitution, submitting that the respondents are presumed innocent until proven otherwise. He further contended that the respondents were not flight risks as they had permanent places of abode within Nairobi and Machakos counties. On the issue of the land, counsel reiterated that the matter had been concluded and an eviction had already taken place. Counsel Angela Mulwa introduced herself as an advocate of 26 years standing and also as a daughter of the first respondent and sister to the second respondent. She narrated to the court the circumstances that led to the arrest of the respondents at their home and stated that she was allegedly assaulted during the course of the said arrest. Counsel Dunstan Omari submitted that the two respondents ought to be released on reasonable cash bail terms, contending that the police cells were unsafe for them, particularly in light of the account given by Counsel Angela Mulwa regarding the circumstances surrounding the arrest. He urged the court to take judicial notice of the vulnerability of the respondents in police custody and need to safeguard their constitutional rights. Counsel emphasized that the first respondent, being a 75-year-old senior citizen, falls squarely within the category of older members of the society contemplated under Article 57 of the Constitution and is therefore entitled to special protection and dignified treatment by the justice system. He further submitted that she is a presidential aspirant in the forthcoming 2027 general elections and contended that her arrest formed part of a calculated scheme aimed at frustrating her political ambitions and unlawfully removing her from the ballot. With respect to the second respondent, counsel submitted that he is a practicing advocate of the High Court of Kenya who runs an active law firm, and continued detention will severely prejudice his clients who will be deprived of access to legal representation and services. He urged the court to consider the broader implications of his incarceration on the administration of justice and the rights of third parties who depend on his professional services. Counsel further implored the court to take into account the personal history of the first respondent, noting that she is a divorcee with the said marriage having been dissolved over 20 years ago, and he submitted that she bears no ill will, vendetta, or motive whatsoever that could reasonably construed as giving rise to an intention to commit the alleged offense, including any suggestion of homicide. In conclusion, counsel passionately urged the court to extend the benefit of doubt to the respondents and to treat them, and I quote, as a favorite children of the law, end of quote, deserving the court's protection, fairness, and constitutional compassion. Counsel Shadrach Wamboi commenced in his submissions by conveying his condolences to the family of the deceased. He urged the court to approach the application with due regard to the constitutional protection of the right to liberty and the circumstances under which the respondents had been arrested. Counsel invited the court to be guided by the decision in Republic versus Michael Rotich, particularly on the danger inherent in the approach of arresting a person first and thereafter undertaking investigations in an attempt to justify continued detention. That investigating process ought not to be used as a basis for unnecessarily depriving an individual of his or her liberty where the investigations could be undertaken without continued incarceration. Counsel further relied on the case of Republic versus Sudi Oscar Kipchumba on the principle that the state bears the demonstrate that continued detention of an individual constitutes the least restrictive measures available to it. He submitted that in balancing the competing interests arising in a potential of the individual, the victims and their families, the public, and the proper administration of justice, and determine whether detention is genuinely necessary in the circumstances. Counsel consequently urged the court to find that the prosecution had not demonstrated sufficient compelling reasons to warrant the continued detention of the respondents for the period sought. In reply, prosecution counsel Ms. Naomi Wanjiru submitted that the right to bail is of compelling reasons warranting its limitation. Counsel contended that the state had satisfied the requirements contemplated under Section 36A of the Criminal Procedure Code and had placed sufficient material before the court to justify the continued detention of the respondents. On the issue of interference with witnesses, counsel submitted that some of the key witnesses are members of the deceased family and are well known to the respondents. She contended that given the relationship between the respondents and the potential witnesses, there existed a real and appreciable risk of interference should the respondents be released at this stage. Counsel further submitted the gravity of the intended charge, coupled with the severity of the sentence that may follow upon conviction, constitutes a factor capable of motivating a person to interfere with witnesses or otherwise obstruct the course of justice. Counsel also invoked Article 27 of the Constitution, submitting that every person is equal before the law and is entitled to equal protection and equal benefit of the law. On his part, Mr. Nyaga, the landed prosecution counsel, submitted that the state had advanced sufficient reasons to warrant the detention of the respondents for the period of 30 days sought in the application. He contended that an application for the continued detention of suspects for purposes of completing investigations is determined on the basis of a balance of probabilities and not on the higher criminal standard of proof beyond reasonable doubt. Counsel further referred to Article 24 of the Constitution on the limitation of rights and fundamental freedoms. He submitted that in the circumstances of the present case, the right to liberty could not be considered in isolation from the constitutional framework governing the rights of arrested persons and the circumstances in which such rights may lawfully be limited. So therefore, it's not in dispute that bail is a constitutional right as provided under Article 49(1)(h) of the Constitution, while accepting that the text of Article 49(1)(f) of the Constitution may in certain circumstances and context comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state application to have him so held. The applicable test is whether the applicant has advanced and proved compelling reasons. The prosecution submitted the seriousness of the offense, interference with investigations and witnesses, and the safety of the respondents and public order. I'll begin with the seriousness of the offense. It cannot be gainsaid that the offenses in respect of which the respondents are being investigated are grave and weighty. The seriousness and gravity of an offense, particularly when considered in light of the sentence likely to follow upon conviction, has been held in numerous decisions to be a relevant consideration in determining whether to grant or decline bail. However, the seriousness of the offense standing alone does not necessarily constitute a compelling reason for the denial of bail. Interference with witnesses and investigations. The prosecution alleges likelihood of interference with prosecution witnesses and the investigations. It has been held by a number of authorities that is the most potent ground, and if proved, the prosecution's allegation of likelihood of interference with prosecution witnesses as such amounts to an affront to the administration of justice, thus is a justifiable reason to limit the right to liberty. In the case of Jackton, Mayende, and 3 others, the court held that, and I will quote, "In all civilized systems of courts, interference with witnesses is a highly potent ground on which the accused may be refused bail. It is a reasonable and justifiable limitation of right to liberty in law in an open and democratic society as a way of safeguarding administration of justice. A cardinal tenet in criminal justice, social justice, and the rule of law envisioned by the people of Kenya in the preamble to the Constitution of Kenya 2010. Threats or improper approaches to witnesses, although not visibly manifest, as long as they are aimed at influencing or compromising or terrifying a witness, either not to give evidence or to give skewed evidence, amounts to interference with witnesses, an impediment to or perversion of the course of justice. And if it is so found, it is a justifiable reason to limit the right to liberty of the accused." End of quote. In the case of Republic versus Dwight, Sagare, and 4 others, the court held that, and I'll quote, "For the prosecution to succeed in persuading the court on this criteria, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect incriminating communication between the accused and witnesses, close familial relationship between the accused and witnesses, among others." End of quote. It is common ground that the first and second respondents are mother and son respectively. It is also noted that the first respondent is the former wife of the deceased husband. The court further notes that there was an existing land dispute, the subject of Machakos ELC, case number A111 of 2025, in which the deceased was named as a third respondent. According to the investigating officer, the deceased had previously reported an incident which allegedly occurred on 7th of July 2026 along Gong Road near Junction Mall. It was alleged that while driving along the said road, 2 men riding on a motorcycle approached her and attempted to shoot her. The deceased is said to have managed to escape from the scene and consequently reported the incident at the police station, that is Kilimani Police Station, via OB number 63/07/07/2026. The investigating officer further informed the court that in the said report, the deceased allegedly identified the second respondent as the pillion passenger on the motorcycle. This allegation is, however, yet to be tested through evidentiary process and must at this stage be treated as an allegation forming part of the material placed before the court in support of the application for continued determination. The foregoing circumstances are relevant to the court's assessment of the alleged gravity of the matter, and in particular, the prosecution's contention that the respondent may pose a risk to witness or otherwise interference with the course of justice if released. The existence of a prior report allegedly implicating the second respondent, when considered together with the existing relationship between the parties and the history of the land dispute, is a matter which the court is entitled to take into account in determining whether threshold of compelling reasons has been met. Nevertheless, the court must guard against making definitive findings on disputed facts at this stage. The question before the court is not whether the respondents are guilty of the offenses under investigations, but whether the material before it discloses compelling reasons sufficient to justify the exceptional step of depriving them of their liberty for the period being sought by the prosecution. Number 3, safety of the respondents and public order. On this limb, the deponent averred that the murder had generated widespread public interest and significant public outrage due to the circumstances under which it was committed and the profile of the deceased, and that the identities of the respondents have become known to members of the public and to the deceased family. Consequently, there exists a genuine apprehension that if released before investigations are concluded, the respondents may be exposed to retaliation, mob justice, or other threats to their safety, and their continued detention is therefore necessary to not only to facilitate investigations, but also to safeguard their own security pending the conclusion of investigations. However, it is the duty of the state to provide safety and security to its citizens. In the case of Republic versus Mujira, criminal case number E001 of 2024, where the learned judge held as follows, and I'll quote, "This court's view is that the ground that the security of the accused is threatened by members of the public or family of the deceased should never be encouraged as a ground for denial of bail, unless there is real evidence of actual threat, lest we should inadvertently promote or condone violence, disorder, and usurping of law by individuals or a group of people." End of quote. I find that the arguments that the respondents be detained for their own safety and security without real evidence. In conclusion, and taking into account all the foregoing circumstances, when considered cumulatively, are highly relevant to the court's assessment of the prosecution's contention that there exists a real and substantial risk of witness interference. The sequence of events, including the prior report of an attempted attack, the subsequent reports of threats to life, and the eventual shooting of the deceased on 29th of July 2026, provides a factual matrix that cannot be ignored at this interlocutory stage. In the court's view, this pattern of alleged escalation is indicative of a serious risk not only to the integrity of the investigation, but also to the safety of the potential witnesses. In the circumstances, and taking into account the totality of the material placed before the court, there is sufficient basis to conclude that compelling reasons have been demonstrated to justify the continued detention of the respondents. This is necessary to prevent actual or perceived interference with witnesses and ensure that ongoing investigations are concluded without obstruction until their completion. Therefore, the upshot is that I hereby direct and second respondents shall be remanded in custody at Kilimani Police Station and Kileleshwa Police Station respectively for a period of 20 to express its sincere appreciation to all the learned counsel appearing in this matter for their diligence, erudite and well-researched submissions. Those are orders of the court.
Much obliged also. Much obliged.
Much obliged.
Your Honor, you can specify who goes to Kilimani, who goes to...
The first respondent shall be held at Kilimani Police Station.
That's the first.
First.
Yes.
Yes.
Second
at Kilelesho.
at Detention.
Yes.
Much. We appreciate you. Thank you very much. Because we have councils, it was a tough fight. Nothing personal with the state. We are always in love together. Thank you very much.
Thank you, Your Honor, for that detail. Truly, we appreciate it.
Just for housekeeping, do we fix it for a mention after 21 days prosecution?
Yes, Your Honor. You can take a mention date.
21 days from today up to 24th. So 25th, to mention it on 25th.
Yes, Your
Mr. Mbithe, 25th.
25th.
Yes.
That's okay.
Mr. Kufuna,
That's convenient.
Mr. Omari. Mr. Omar, we're fixing a mention 25th after the period.
That's it.
25th.
That's it. 25th is perfect, Your Honor. Will you take time allocation?
Time allocation. What time do you want us to mention it?
What's your
Commission at 11.
11.
11?
It's okay.
Of course.
Thank you very much and have a good evening.
Stay.